I'm Lee Pacchia, and you are watching Bill on Bankruptcy. I'm joined now, as always, by the star of our program, Bill Rochelle, Bloomberg News bankruptcy columnist. Lots to go through this week, Bill. Our first story is related to AMF Bowling, which is back in Chapter 11 after 11 years of being out in the wild, so to speak. Previous to that, they were, of course, in Chapter 11. What are your observations on this particular case?
You know, I'm wondering if bowling is another buggy whip kind of a business.
Yeah, people don't bowl anymore.
Well, that's the issue. They're back in Chapter 11 this time with 250 bowling alleys. In their first bankruptcy back in 2001, they had 500. So they've already shrunk by half, and one would suspect may get smaller yet. This time around, it doesn't look like such a terrible case if you are a secured lender owed $216 million. Because they are supposed to get $150 million of borrowed cash, and the new stock, second lien lenders, and pretty much everybody else is almost entirely wiped out. The question that I have is whether or not bowling is a big enough business now to be able to justify a corporate overhead or a corporate structure like AMF's with 250 locations and things of that sort. I'm wondering if this is a business these days, because of the decline in the popularity of bowling, that to be profitable needs to be operated by individual operators who, sad to say, sort of like in mom and pop supermarkets, are going to have to work 60 to 80 to 100 hours a week.
The next segment is one we're calling the train wreck of the week. Who is it?
Well, that has simply got to be Hostess, and I'm sad to say because I do adore some of their products. The bankruptcy court was called upon to impose contract concessions, that is, wage reductions of about 8% on the bakery workers union. This was after the Teamsters union, the drivers, did voluntarily accept those cuts. However, the bakery workers union were entitled to strike, and guess what? They did. And not only that, Teamsters, to some greater or lesser degree, are honoring the picket lines. This, I think, seems to be, unless they can get this strike settled, on the verge of ending Hostess as a business. In other words, forcing it to liquidate. This will be let's call it the end of a remarkable, at one time, very valuable American brand name. And of course, speaking of valuable American brand names, Kodak comes in a close second when it comes to destroying the value of what was once an extremely valuable company. Kodak, of course, as we know, has blown off about $500 million worth of cash since they filed in Chapter 11 early this year. And at the end of the day, it's going to be a question, Lee, between Hostess and Kodak in the what may be liquidations of both. Which is
not
worse?
A happy segment.
Which is worse?
Yeah, these are big American names we're talking about.
Well, we said this before. You have to reinvent a company and its products every few years. If you don't, this is what happens.
And that's just not happening here. Speaking of good businesses that are in the process of being ruined, how do you feel these days about J.C. Penney?
Oh boy, you put your finger on another company that I absolutely adore. I have been shopping in J.C. Penney since I was a little kid. J.C. Penney, Sears, Home Depot, and Lowe's are the only places I will voluntarily go to shop. You got to drag me anywhere else. And I do adore Penney. There are some of their products of which I will wear nothing from anybody else. They have relatively new management, which installed about a year ago a new marketing and promotional strategy. And guess what? It has turned around the company in dramatically quick fashion. However, they turned it around the wrong way.
Oh dear.
Same-store sales in the last quarter were down 26%. That, by the way, is not a typo.
In a quarter.
26. Well, 26% year over year. In other words, more than a quarter of the sales declined year over year. The loss in the quarter was $156 million. And by the way, that was an operating loss. Net loss actually was a little bit less because of tax benefits. The question that I have for our listeners is, how long is it going to be before the board at J.C. Penney gives up on this strategy and has management either change its marketing strategy or bring in somebody else to do it? at the end of the day, if you keep on losing sales at this rate, you're just not going to be around forever.
We have a couple want ad for the next segment. Which companies are for sale this week?
Well, first off, we have New Energy Corp. It is a 100 million gallon a year ethanol plant in South Bend, Indiana. And that is in the court in South Bend, right in their hometown. If you are in this kind of an energy business, step up right away, and I suspect you can buy it. The next is North Texas Community Hospital. This is a 36-bed hospital in a town about, I think it's 50 miles northwest of Fort Worth called Bridgeport, Texas. There is already a buyer for this one. If you're interested, go and visit the bankruptcy court in Fort Worth. And the third and last one is my favorite. It's called Big Island Carbon. It makes activated charcoal out of macadamia nuts.
What? That makes no sense. Did they also make paperweights out of diamonds? I mean, macadamia nuts are expensive as all get out. How on earth can you have a business turning expensive nuts into charcoal?
Well, that's a good question. Actually, what they do is they use the shells to turn them into activated charcoal.
Okay,
but evidently,
well, I guess that's a little
it makes a little bit more
feasible,
sense.
at least in theory. But they're still in Chapter 11.
They are, and of course, did they file in Hawaii? No. They filed in Delaware. But so if you want to buy it, go to Delaware.
Right on. And we have a couple of advance sheets that we're going to go offshore this time. I gather the Supreme Court in the UK had an important decision on multinational bankruptcies. Big topic for this year. What does it mean for the United States?
Well, at first blush, you would think that anything the Brits say about multinational bankruptcy don't make no difference at all over here in the U.S., but it might. To get to that point, let me first tell you what the UK court said. This was a decision, by the way, called Rubin from the UK Supreme Court, which, as the name suggests, is the highest court in the UK. This decision held that the UK courts would not enforce a default judgment against a UK company if that company had not filed a claim in the foreign bankruptcy proceeding, wasn't present in that foreign country, and did not defend the suit. They simply said, we're going to follow what really is 19th century British law. They are not recognizing the so-called long-arm jurisdiction of another court from another country, and they would not enforce this default judgment. This is a bit of a blow for somebody like the Bernie Madoff trustee. I think the importance immediately for the U.S. is a bit different. There was a case argued in the U.S. Court of Appeals in New Orleans at the first part of October involving Vitro, the Mexican glassmaker. And Vitro was making the argument to the Fifth Circuit that the U.S. courts made a terrible blunder in not enforcing the Mexican bankruptcy reorganization plan. So therefore, when I bring these two together, what I come away with is the idea that the UK decision tells the judges in New Orleans that refusing to enforce a bankruptcy decision from another country is not such a radical development after all.
All right. Thanks for that, Bill. That's what we have for this week. If you'd like to learn more about the cases and issues we just discussed, be sure to go read Bill's column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.